Good afternoon. Welcome to Division 5 of the Court of Appeals. We have two cases scheduled on the 1:30 docket. Are counsel for both cases present?
Yes, Your Honor.
I think we have experienced counsel here, so I can skip most of this. We are live streaming these oral arguments on the internet for those of you who are in the audience. So please remember your arguments being recorded and will soon be available on the Judicial Branch website. So please take care in mentioning any confidential or sensitive information. I know that we have cases with sexual assault victims and minors today, so be aware of that. If anyone in the courtroom has any electronic devices, please turn them off, because even if you're just receiving an email or sending a text, it can interfere with our audio system. We are ready to proceed unless counsel have any questions with our first case, which is People v. Ceballos-Rios, 15CA1823. Counsel, when you're ready.
May it please the court, Andrew Hare on behalf of Mr. Esteban Ceballos-Rios. I'm going to address my comments principally to the first argument dealing with prosecutorial misconduct and closing arguments, specifically with regard to the misleading arguments together with the repeated references to the truth, so to speak, during the closing argument as well. And so that's where I intend to go today, but I'm happy to answer any questions the court may have about other matters in this particular case. We're dealing with plain error in this regard, and so I'm going to address the first prong, basically dealing with error, and then I'll move to the question of prejudice, the lack of reliability in this conviction, and why this court should reverse Mr. Ceballos-Rios' convictions. Just by way of a little bit of background to establish or to kind of underscore the error in this particular case, the court's probably familiar with the facts. What we have here is the Boulder District Attorney's Office prosecuting my client, but they're also at the same time prosecuting CR and SC. CR is the alleged victim. SC was her partner and was a key prosecution witness. Now, on the first day of trial, the prosecution came before the court and was basically asking for kind of what are the parameters of how this information could be admissible. They referenced possible direct examination by them, but also in cross-examination by defense counsel. They revealed that the offenses for which CR and SC were charged was false information to a pawnbroker. Under Colorado law, that's a crime of dishonesty. On its face, its name connotes dishonesty, untruthfulness, deception. They recognized that, they acknowledged that much. SC had pled guilty already to a misdemeanor. However, the factual basis under Segovia could be drawn into, to the jury's attention. And so at this outset of the jury trial, this was dealt with, and the court issued what was basically an order, if you will, about how this information could be addressed during the trial. Prosecution didn't bring it up during trial, but the prosecution understood from its earlier discussions about what these offenses were and the import of these offenses, what it meant to motive. They specifically addressed it when they were talking to the court. They also knew what it meant with respect to my client, because in closing argument, they referenced that Mr. Ceballos-Rios had a motive, something at stake here. He's the one who had a motive to testify as he did. He did testify in his defense. He had no prior criminal record that was adduced at trial. So at this point, in closing, they also, however, with respect to the error that ended up occurring, also mentioned that CR had no motive. One of a defense issue at trial was that CR and SC were in a relationship at the time of the event, but that had ended, and by the time of trial, they were no longer in a relationship. Part of the defense effort was to draw into question her motive or her credibility by reference to this relationship, and that she had made these allegations against Mr. Ceballos-Rios because she didn't want to, or she was trying to save the relationship. She didn't want to offend her partner. The prosecution's response was, well, that is ended. She has no motive. The only motive she has basically is to tell the truth. That was the import of the argument, that she was sexually assaulted. This is the misleading argument. The prosecution knew that this inference was basically a false one. It was a misleading one because they had information that their office, and this case is a little bit different. The circumstance is a little bit unique, a little bit different than most cases. Generally, usually what we see is the Arapahoe County District Attorney's Office is prosecuting a client and they have some peripheral witnesses who have pending felonies, say in Denver. And typically they bring that out. They say, do you have a pending felony? Yes, or charge in Denver? Yes, I do. You know, do I have anything to do with that? No, you don't. Have I made you any promises? No. That kind of thing. In this particular case, we have a unique situation in which this particular Boulder District Attorney's Office is prosecuting my client at the same time as they're prosecuting the alleged victim in SC. That should raise the question of as part of my argument also, is an obligation to have candor with the tribunal, candor with the jury, and an obligation to not at least make strikingly misleading arguments. The poll star issue in this case was one of credibility. That clearly was the case. It was the case from the outset in the opening statements. It was clear during the trial, and it certainly was made clear during closing argument, including and not limited to this event, this misleading argument that was made during the closing rebuttal part of argument. I also have informed the court, and the state has as well, that this particular felony charge against CR was dismissed a week after she testified. The state mentioned something about, well, it's not really relevant. First, the relationship was over, so there was no motive, and this particular alleged criminal conduct was not related to the event in question. Well, first, because, as I indicated in the reply brief, because if it's assumed that the relationship is over and somehow the motivation question is dissipated or not drawn into question because of that fact, it's even all the more true that this particular pending felony would have all the more import and effect with respect to CR's credibility.
Counsel, on this issue, how do we know whether the statement is misleading? No questions were asked of the witness concerning the pending charges, so we just don't know what the circumstances were. We don't know if at the time she testified, she had any reasonable hope or expectation of leniency. We just don't know. Maybe she didn't.
Well,
You're asking us to assume she did, even though there's no record of that.
well, under Colorado law, the fact of the conviction, or excuse me, the fact of the pending charge carries with it basically an inference, a legal inference, that one is charged with, is deceptive, is untruthful. I mean, Mendez, I think, makes that very clear, that is the effect of a pending felony involving a crime of dishonesty. In terms of, we don't know what her hope or expectation is. That is assumed from the fact of the pending felony. I mean, the inference is drawn, certainly it could have been drawn, assuming it were introduced at trial. The prosecution would undoubtedly say, we promised her nothing, etc. But the promise, and even if she were to say, I don't have any hope or expectation of leniency, the bias is both with respect to the pending felony and the nature of the felony, and the attack on her character is not just general, but also as to her character for truthfulness because of the nature of the felony. I want to point out also, and I don't think I made clear, is that also we're dealing with a relationship here. I mean, typically, as I said in my earlier kind of example, the prosecution doesn't have a relationship with the witness that they're examining and the pending felony at issue. It's another office. It's another judicial district that's dealing with it. In this particular instance, the relationship between the prosecution and these witnesses is indisputable, and it's important. And it's a relationship that was also brought up during the closing argument about relationships, if you will, with respect to CR and SC. But in this particular instance, the relationship between the prosecution's office and the witness, in this particular instance, itself also draws into question a question of bias and the hope or expectation of leniency.
So is your argument that the prosecution's failure to inquire of the witness and to make sure that the jury had this information alone was reversible error, or was it that the prosecution's failure to inquire combined with its closing argument was the reversible error? Or are either of those?
Well, I would
sufficient?
tried to separate those out, and I'll try to do that to make sure I'm being clear. One is that the trial court failed to interject. Really, as to the plain error, as to the closing argument, this is the trial court's responsibility. With knowledge and information, it has now a responsibility to keep in line, if you will, the parties, and in this instance, it's the prosecution with respect to arguments that it's hearing that are misleading. The same would be true if this were a trial to the court and that this kind of argument were made to a tribunal where neither party had introduced into evidence this information. A trial court would step in and say, you can't make that argument to me, counsel, because I know you told me earlier that these particular witnesses have pending felonies against them. The separate other issue is the responsibility of the prosecution to have brought this to light. I think there is, because their duty is to seek justice, not to win, I think these facts kind of really underscore that the overriding interest of the prosecution was to win rather than to seek justice. And so that's separate.
Excuse me, counsel, but given that the defense counsel was not bringing any of this out, could the trial court judge have concluded that for some reason it was to the advantage of the defense not to mention this?
No, nothing was brought out at the time that this was raised by the prosecution, as I indicated. Nothing was brought out at the time that this particular information, if it were adduced at trial, would have triggered the introduction of some other evidence that somehow would have been countervailing to the defense.
But isn't this really an IAC claim?
Well, they're two separate questions, and yes, indeed, I believe that this counsel was ineffective. I think that there are two different tests under Hagos. We deal with plain error on the one hand and then Strickland test on the other. So it is an IAC claim. I think at the appropriate time, Mr. Ceballos-Rios can raise that. However, I think that under these facts, under this scenario, under this history, in this particular case, that it rises to the level not only of error, but also that it's flagrant and it's tremendously improper.
I don't think I've ever seen an appellate case where any of the appellate courts have said that the district court has a duty to do this type of thing that you're arguing for here.
Well, keep in mind, the plain error argument with respect to closing argument is that the court should have interjected and stopped the argument. In other words, the argument's improper. The two other issues are, one is
Right, but going back to the point you were
Sure.
just making, I don't think I've ever seen an appellate case that says that the district court has a duty to do that.
Well, I
Is
think
there
it
one?
was either Wendt or Domingo Gomez where the court itself interjected and stopped, sua sponte, told the prosecution to stop using the word lie. In other words, interjected itself because it felt it was improper. That would be akin to what we're arguing here, is that this information, that with the court having knowledge of it, of this particular information, and knowing the real setting in which these witnesses were sitting in the sense of the relationship between the prosecution and the information that they had, that this kind of argument should have alerted the court was obvious, should have been obvious to the court, and such that the court would stop the prosecution from making this kind of argument. I see I have about 2.5 minutes left. I'd like to reserve my remaining time for rebuttal.
You may.
Good afternoon. May it please the court. Kevin McReynolds on behalf of the people. The core of defense counsel's role in our adversarial system is to be captain of the ship in determining what evidence to present and what strategy to employ. Decisions on what witnesses to call and whether and how to conduct cross-examination are the exclusive province of defense counsel. And here, defendant's claims all relate back to a choice his defense counsel made at trial, a strategic choice, a tactical choice, not to present this extrinsic, unrelated, subsequent transaction evidence to attack the credibility of a rape victim and her former fiance.
Excuse me, counsel, but
Yes.
is there anything in the record that indicates that it was a tactical decision?
Yes, Your Honor. The record itself shows that it was affirmatively and expressly addressed before trial. This was a known right, and the court's order was phrased in very clear terms of precisely how this evidence could come up. I think the quote was, "So I'm going to permit the defense to ask questions of the victim's former fiancé as to whether she provided false information to a pawnbroker. They may ask questions of the victim as to whether she has pending charges of false information for a pawnbroker, and they may ask questions related to her expectations or hopes of leniency." This is not something like Redinger, where we have a legal issue that's somewhere in a document that could have been overlooked. This was expressly and affirmatively addressed. There was a direct order from the court on defense. We recognize that this issue, this is how this evidence can be presented, here's what you can ask, and then chose not to do it. That is sufficient for you to recognize this under either framework of invited error or waiver. Invited error bars issues of trial strategy, but not errors resulting in oversight. There's nothing to suggest oversight here. This was a known issue. This was a clear order.
Well, counsel,
Yes.
that may concern the first issue raised by counsel.
Yes.
Which is that the prosecutor or the court had some obligation to raise these matters. But I don't think it gets to the second issue, which counsel was spending time on, which is what the prosecutor said in closing argument. Now, even if there was a waiver invited there as to the former, and I'm not saying there was, that wouldn't allow the prosecutor to make a misleading statement to the jury.
I agree with that in principle, Your Honor, and I don't think there was a misleading statement to the jury. The argument, this is rebuttal argument, this is responsive to defendant-specific arguments regarding the motivations. And if you look at the circumstances of this pawnbroker offense, it occurred 2 months, this is something that wasn't mentioned, 2 months after the immediate report by the victim here, the SANE exam, the arrest of defendant, and this is totally unrelated. The fact that there is this charge could not be viewed as something that is particularly motivating her to make these accusations because she'd already made them. So to the degree it was inartful, it was, one, responsive directly to the arguments of defense counsel. Two, it was phrased specifically in terms of the credibility instruction, which is an appropriate manner in which to address credibility issues. And three, given its minimal probative value on credibility, this probably explains the strategic choice made here to not bring up this unrelated subsequent event that had no connection whatsoever to the accusations when they were made that occurred months afterwards.
But what about
Yes.
what about the motivation to persist in the accusation? That is, okay, she might have had another motivation that went away, but now she has a new motivation. She has a pending charge hanging over her head.
And I would suggest that that is probably too fine a distinction to be claiming to be obvious, plain error on closing argument where there was no objection whatsoever from defense counsel. I agree with you. I see what that point is. I would say that it is not obviously, flagrantly, aggressively misleading. And then to sort of turn to the second point of, and even if that was error for the court not to spontaneously object to that particular comment in the course of this whole trial, it did not result in the substantial prejudice required in order to reverse for prosecutorial misconduct at closing argument, because it is this fine point. It is this fine distinction of, well, maybe she had some additional possible motivation to persist in her accusation, even though she had already made it months before the supposed incident, knew that her former fiancé had it reduced to a misdemeanor. It's not enough, and especially when you look at the totality of the record here, which was pretty overwhelming even in a he said, she said type of sex assault case. There was physical evidence that all supported the testimony of the victim and that contradicted defendant's trial testimony, which was his third different version of events after having first claimed to have no idea about anything about a party, then having been present with the victim, not knowing who she was and only for a few minutes, but insisting that no sex had taken place until such time as DNA evidence proved that he in fact did.
Shouldn't the
Your
court be particularly cautious about allowing improper commentary on credibility in a case where credibility is the central issue for both the prosecution and the defense?
It is something that the court should be sensitive to, Your Honor. And again, for the reasons I stated to Judge Jones, I don't think this was a flagrantly improper argument. What we're dealing with is sort of a fine point of whether or not there would have been some possible additional further motivation for her to repeat exactly what she said the day of the rape, the day of the SANE exam, after repeated police interviews. I don't think that is, I don't think it meets the standard required for a plain error type of prosecutorial misconduct at closing. Point regarding the record, there was the question asked about whether or not there was the possibility of there being promises made or anything. That was in the record. If you look at the transcript, June 15th, this is during the discussion of the prior offenses during the first day of trial. Pages 123 to 124, the prosecution explains that there were no promises of leniency made and that it was his understanding that the victim had surrendered pursuant to the warrant. She had moved out of state at that point, and so that was, she had come back in order to testify in the trial. So as the first point, I would go back to the points that this is plain error, or this is invited error, this is waiver. This is not an issue that is reviewable with regard to the presentation of evidence regarding these subsequent unrelated offenses as they related to potential issues of credibility.
Mr. Hare argued in his reply brief that you waived any argument that there wasn't any error here by not addressing the merits. That you focused on invited error, waiver, didn't address the merits. What's your response to that?
I guess my response would be, with regard to the first argument, I did not waive the idea that this was not obvious or any kind of error. I'm saying it's not reviewable at all because defendant absolutely invited this error, waived a known right by choosing not to do it. To the extent this court chooses to view that as a concession, obviously you don't have to accept my concession, implied as it might be, and you can consider whether or not, as Judge Terry pointed out, there's any case anywhere that ever suggested the trial court or the prosecution is obligated to impeach crime victims spontaneously when defense counsel has been specifically given a direct order as to how they can present that evidence. That would suggest there's no obvious error here.
Counsel, I think what perhaps is underlying Judge Grove's question there is the suggestion that perhaps it would be in your office's best interest not to rely on procedural defaults, but go on to address the merits of arguments. That would help us.
I understand that, Judge Jones. I thought this particular case was the most obvious example of invited error that I thought I could find in a case involving evidence. Again, the core role of defense counsel is to define the scope of cross-examination. That is an exclusive province of defense counsel in our adversarial system. If defense counsel then wants to complain about if defendant then wants to complain on appeal about the scope of that cross-examination, that is an ineffective assistance of counsel claim. There is a remedy for relief, but it's very, very clear that under invited error, it cannot be addressed. It should not be addressed by this court on direct appeal.
Well, be that as it may, we might disagree with you on that. And I think you have to take account of that in the way you brief your cases. I mean, relying on just a procedural default does not help the court. I'm just telling you. And on invited error, I think it would be one thing if defense counsel had told the prosecutor and the court, don't ask these questions. That would have been invited error. Okay, that's not what happened here. We have passivity, okay? Defense counsel being aware of something and choosing not to do it. That creates an ambiguity under Rediger as to waiver. I don't think it shows invited error at all.
And I would respectfully disagree, Your Honor, because I don't think that there's anything that could be clearer invited error than complaining about the scope of cross-examination you chose not to address. I would point to Perez-Rodriguez among the cases involving invited error and waiver that explain that we look at the record to determine whether it's a deliberate or an inadvertent error in making that assessment. This, like in T and Perez-Rodriguez, we have affirmative conduct, defendant specifically addressing the specific issue with the court. That is very, very different from Rediger. That is why this case clearly falls on the side of the line where if you want to complain about the defense strategy or the defense choices as to questioning, you have a forum that's ineffective assistance. You do not bring those complaints to this court on direct appeal. If there were any questions regarding the other allegations of prosecutorial misconduct at closing, that other than the motivation one, which I think we've discussed.
Hearing none, I'm just going to echo my colleagues' comments. It would be helpful to move on to the merits as well, once whatever invited error or waiver comment or arguments are made.
I understand, Your Honor. If there are no further questions, we ask this court to affirm defendant's convictions. Thank you.
May it please the court. Counsel referenced defense counsel as complaining about the scope of cross-examination. He actually didn't do that. This was raised pre-trial by the prosecution seeking guidance as to what would be permissible and not permissible. Defense counsel did not complain about anything. He simply threw in his 2 cents worth, and when the court said, this is what I'm going to permit, defense counsel concurred. Defense counsel didn't invite the error. That would require, I think as Judge Jones had given an example, would require something along those lines. In terms of waiver and intentional relinquishment of my client's right to cross-examine about fundamental impeachment evidence, that didn't happen either. We wouldn't go on a cold record to obtain waiver of a defendant's cross-examination and due process rights. With regard to the circumstances of the pawnbroker information, I would point out also that during the discussion, the prosecution noted that CR and SC were pointing the finger at one another. So in this particular instance, not only were they charged with crimes of dishonesty, but they were also arguably being dishonest with the prosecution, who was going to call them as witnesses. The state asserts that it's of minimal probative value. Colorado says otherwise. It's extremely probative and extremely relevant and probative of one's lack of credibility. With regard to that issue, that's up to the jury. Again, this is a jury question. The jury should not have been misled to believe that CR and SC, in particular CR, had no motivation other than to come in and tell the truth regarding the alleged sexual assault. And with respect to the evidence, the prosecution's closing argument would belie the notion that this was overwhelming evidence. This case, again, was the Polestar issue was credibility. It was a credibility contest between the CR's allegations and Mr. Ceballos-Rios' testimony in his defense. With that, I would ask the court to reverse Mr. Ceballos-Rios' convictions and remand for a new trial. Thank you.
Thank you, counsel, for your arguments. The case will stand submitted and a written opinion will issue in due course. With that, you can pack up and we will call the next case, which is People v. Lee, 16CA1567. counsel. We're ready when you are.
May it please the court, my name is Meredith Osborne, attorney registration number 50469, and I represent Mr. Lee. Today I would just like to focus on the initial aggressor exception to self-defense. However, if the court has any questions about the other issues, please feel free to inquire.
Can I ask a question before you get started on the initial
course.
aggressor then? I just want to be clear what your position is. In your opening brief, you argued that the photograph had no probative value, but then you also argued that it had minimal probative value. Which is it?
I think the photo had minimal probative value.
Okay. Then go ahead.
Okay. Instructing the jury on the initial aggressor exception to self-defense is only warranted when the prosecution presents some evidence that the defendant initiated the physical conflict by using or threatening to use imminent and unlawful physical force. And what this means is that the defendant did something so aggressive, it triggered the victim's right to legally use physical force against him. So we ask, in this case, when did the alleged victims become justified in using physical force against Mr. Lee? And the answer is when he began shooting towards them. The trial court relied on two different pieces of evidence to conclude that the initial aggressor exception was warranted in this case. First, it initially said that the text message rendered Mr. Lee the initial aggressor, but it also said the fact that Mr. Lee came back to the apartment complex with DH, walked by the group of teenagers, went outside and waited for the teenagers, and then began shooting was also evidence that the jury could consider the initial aggressor exception and therefore conclude Mr. Lee did not act in self-defense. Both of these pieces of evidence that the trial court relied on did not actually support the initial aggressor exception. With respect to the text message, there are three primary reasons why that did not render Mr. Lee the initial aggressor. First, quote, "One cannot acquire the status of initial aggressor by association," and that's Manzanares relying on Beasley. Mr. Lee never sent this text message. He had no idea about this text message. It's not even clear that DH sent this text message. The alleged victims didn't see this text message. They heard about it, and it was only admitted to show why AB had brought his gun to the fistfight as well. And that bleeds into the second problem with relying on the text message. It wasn't admitted for its truth at trial. The trial court repeatedly said that it couldn't be imputed to Mr. Lee, and it makes no sense to instruct the jury on an initial aggressor exception relying on the text message that the jury itself couldn't use to find beyond a reasonable doubt self-defense didn't apply. But even if the text message had been admitted for its truth, again, Mr. Lee never sent it, and it lacked an imminence requirement. The text message was purported to be sent at 9:52 p.m., and Mr. Lee didn't become involved in this case whatsoever until around 10:15, over about 25 minutes later. So when these concerns were brought to the trial court's attention below, it said, well, it's not just the text message. It's not just the text message. It's also the fact that he came back to the apartment complex with DH, and then they walked by the teenagers and went through the lobby and whatnot and waited outside. Again, this fails. Castillo says, when a series of events, such as coming to the apartment complex, walking through, waiting outside, when there's a series of events like this that are one continuous episode, the defendant can only be the initial aggressor when he kicks off the entire episode with the threat or use of imminent and unlawful physical force. And in this particular case, because the fistfight had been agreed upon by everyone, there was no threat of imminent unlawful physical force when they arrived to have the fistfight. And in fact, at trial, AB, who is the only witness to really explain this continuous episode in any detail, he said, I did not perceive their arrival as a threat at all. We pushed back on this on cross-examination. So there were no threats to you then at all? No. And again, that's because they were anticipating this. The group of teenagers was there ready for the fistfight. So again, this is not an imminent threat of unlawful physical force.
Is your position that the judge can't look at the totality of the circumstances, that he has to identify a particular overt aggressive act on the part of the defendant in order to instruct the jury on initial aggressor?
That's not just my opinion. That's what Castillo basically says. It says when there's a continuing episode, we look to who started the continuing episode, and was that begun by a threat of imminent unlawful physical force. And it's really important because initial aggressor is complicated. It's not an easy thing for juries to understand. It's not even easy for me to really understand. What we look to is, when did the alleged victims become justified in using physical force against the defendant? And you can't have an association between the defendant and perhaps one of the other people involved in the case. I mean, DH wasn't even charged as a complicit or an accomplice or anything. To render him the initial aggressor, and that's because this is so critical to the defendant's right to due process and a properly instructed jury. And whether, in Castillo, what they say is, could the jury have been induced to fit facts into an exception that actually didn't apply as a matter of law? And I think that's why the pinpointing matters a lot.
Let's assume that the instruction was improper. Your next argument is that it wasn't harmless. And as I read Castillo, the prosecutor put a lot more emphasis on the initial aggressor status of the defendant than the prosecutor in this case. So explain to me why it wasn't harmless, well, why this case should be treated the same way as Castillo.
Well, in Castillo, there are really two primary concerns in the harm analysis. It's whether the defendant was characterized in closing argument by the prosecutor in general to be the initial aggressor, therefore inducing the jury to fit facts into the exception that shouldn't have been given in the first place. But it's also whether the defendant was convicted of a crime where self-defense applied as an affirmative defense. Both of those considerations are present in this case, even though the prosecutor didn't elaborate on the initial aggressor to the same extent as in Castillo. That was the prosecution's theory. The prosecution didn't even argue provocation. It just said Mr. Lee is the initial aggressor that night. And it's really interesting because the basis for giving the instruction from the trial court's perspective is not what the prosecutor's basis for Mr. Lee being the initial aggressor was in closing argument. In closing argument, the prosecutor said, and I quote, "Lee was the initial aggressor that night. It was him that waited outside the building. It was him that walked towards MJ, and it was him that fired him in the chest." Again, under Castillo, that was just not a correct way of viewing the evidence. It's who started the fight, and was that started by an act or threat of imminent unlawful physical force. This was at the end of the episode, is what I'm trying to say. And because the prosecutor characterized this evidence as rendering Mr. Lee the initial aggressor, the jury would have thought, well, yeah, he shot them. That's why he's the initial aggressor. Yes, he fired first, when in fact, that is not what initial aggressor means. And there was no clarity on that point at any point after the argument was made. And I think there's one other issue that I would just like to bring up to the court about the recklessness findings. And I think this is really interesting in terms of the harm analysis. So self-defense applied as an affirmative defense. And yes, Mr. Lee was convicted of a crime where self-defense applied as an affirmative defense. And under Castillo, that these are relevant to the harm analysis. And
that's the third-degree assault conviction that you're
correct,
talking about, right?
Yes. The recklessness findings are the way, let me take a step back. The way that the jury was instructed in this case, while it is true that as a matter of law, one cannot behave reasonably and recklessly, and therefore a finding of recklessness means that the jury implies that the jury found unreasonableness. The way that the jury was instructed in this case, and this is the self-defense instruction, instruction 16, that said, if the defendant acts in self-defense, he can't be guilty of recklessness. And that is true as a matter of law. But what it allowed the jury to do was say, he didn't act in self-defense because he is the initial aggressor. The prosecution just told us that because he shot the victim, he's the initial aggressor. So therefore, we're rejecting self-defense with respect to all of the convictions in this case, those where it applies as an affirmative defense and those where it's an element negating traverse.
The instruction note also says these affirmative defenses do not apply to the crimes of manslaughter, criminally negligent homicide, et cetera. All the things that have a reckless or negligent mental state required, it said self-defense doesn't apply.
Sure, and I think that that also is why the third-degree assault conviction is helpful to showing harm here, because the jury maybe didn't go with just recklessness. It concluded that he acted knowingly upon finding that he did not act in self-defense. And so one way of making sense of these verdicts is that the jury rejected self-defense across the board upon concluding he was the initial aggressor, and then was merely considering the remaining elements and said, well, yeah, he can act reasonably, but he was the initial aggressor. and still find him guilty of recklessness. And so that's why this is harmful. The way the instructions worked in this case, that's why requires a new trial. And again, there were general verdict forms in this case, so we really don't know what the jury was thinking when it rejected self-defense, but it is possible, based on the argument and the conviction where it applied as an affirmative defense, that they rejected it upon the initial aggressor exception.
Don't we have to assume that the jury didn't follow that instruction in order to agree with your argument here? I mean, the instruction that says these affirmative defenses do not apply to the crimes of manslaughter. I mean, how do we accept your position without also concluding that the jury didn't follow that instruction?
Well, if we presume that the jury follows the instructions that it's given as a matter of law in this state, but even if this court is inclined to believe that the jury went with reasonableness, that they concluded they disregarded the initial aggressor instruction and went with reasonableness, that actually amplifies the harm stemming from the prosecutor's misconduct in argument 3 on the issue of retreat, because then the jury was confused about the issue of retreat and went on to find, possibly based on the argument, that Mr. Lee had acted unreasonably in failing to retreat. So there isn't a relationship between the harm of those two issues. And so I think under that circumstance, a new trial would still be required. Does that answer your question?
I think so.
Okay. And again, the instruction on the traverse, it says you cannot act in self-defense and act reckless. And that's all the jury had to say was, well, he didn't act in self-defense because he was the initial aggressor. So that's why this initial aggressor exception is harmful, in addition to the other reasons already given.
But if they had said that, that would have meant that they were applying the affirmative defense that the instruction said not to apply. That's my concern.
Yeah, I don't read it that way. I think that the jury rejected self-defense as an affirmative defense because of the initial aggressor instruction, and for that same reason found that he acted, they could reject self-defense as an element negating traverse with respect to the other convictions. So I think that it still is possible, and the question is not whether this was virtual certainty, it's whether or not this error reasonably contributed to the verdicts, and I think that is present here. If the court has no further questions, I would like to reserve the remainder of my time for rebuttal.
Good afternoon. May it please the court and counsel, Paul Kaler, 19210 for the people here. On the initial aggressor, we have to look at the totality of the circumstances. And I think the way it comes down, this issue comes down, and I since taking over this case, I found it a little bit interesting, because normally when you see an initial aggressor instruction, you see a provocation instruction. And normally both claims are raised. We only have one claim here. And I think the dispute, or the difference, and I know there are two different theories, but I think the difference on these two theories comes down to the final factual dispute between the parties at trial, which was who pulled their weapon first. Was it the defendant who pulled the weapon, or was it the people they were there to fist fight with? Did they pull their weapon first? But I think in looking at both limitations on self-defense, I think you look at the totality of the evidence before the trial court when it ruled on this issue. And the issue was, well, I'll agree a little bit. I'm not sure the text message pushes the inquiry all that far along. But I think the circumstances leading up to what happened. The defendant and his friend drove at least a couple of miles to the site. The defendant brought his weapon. They parked their car down the street, suggesting getaway type thing. They went into the lobby of this apartment complex, and they looked at and they gave each other the eye and let each other know that they were there for what they went. And then the key stuff is what you see on the DVD. And as the defendant and his friend walk down the stairs, they're waiting for a short time. It appears that the defendant is adjusting the pistol in his waistband. The victim and his friend, they walk down the steps. Then the defendant, at least what you can see from the DVD, the defendant's theory is that the victim pulled first, and he pulled faster, and he shot. I think that brings in, obviously, the defendant's self-defense claim, but it also brings in the provocation limitation on that.
Counsel, it seems to me you're suggesting, at least in part, that the act of self-defense itself can be the initial aggressor act. That doesn't sound right.
Well,
I mean,
I-
that just does away with initial aggressor.
well, if they were both pulling weapons simultaneously, Your Honor, or close in time together, if the defendant started pulling first and the victim started pulling second, the question is, if they come down and you can see from the DVD, the defendant pulls first, he steps towards the victim, opens fire, and then runs away to meet some credible evidence criteria for getting the initial aggressor limitation on self-defense, that should be sufficient to get that limitation, just to provide the jury with that information.
I haven't seen a case anywhere that says the act of self-defense itself can be the initial aggressor act, and I don't see how that could be as a logical matter. I mean, it's conflating the two concepts. It's in effect, it's almost negating self-defense. I mean,
No,
it seems
but
to me.
I don't think so, Your Honor, because under self-defense, it's the,
I mean, and here's why. Because if they're the same act, then it's the same question for the jury, as you just kind of alluded to. Who pulled first? Well, if it's the same act, the jury decides simultaneously that same act was not self-defense and was the initial aggressor act. And that's not how the analysis is supposed to proceed.
well, I think under the deadly use of force statute, it's the use or imminent use of force. Defendant could claim, I started pulling first because I could see that he was doing it. It doesn't, I don't think it negates, but it informs the jury's analysis about whether there had to be any sort of retreat or something like that. The question was, could the defendant claim that he was the victim, which is pretty much what self-defense is, or was it possible for the prosecution to argue that he was the victimizer? I think that just presented the issues to the jury to determine, which comes to our second point, which is the jury only found a reckless crime concerning the shooting except for the third-degree assault, which is obviously the least important, and obviously everything went concurrently, sentencing-wise. But the jury did not believe, or at least had a reasonable doubt, that the prosecution had disproved self-defense beyond a reasonable doubt.
Before you get there, could you address harmless error with respect to at least the initial aggressor instruction and the knowing crime?
Well, I guess it's a little bit harder on that, Your Honor.
So I guess, let me put a finer point on it. If we disagree with you and determine that the initial aggressor instruction was not warranted, do you still maintain that the error was harmless?
There was a greater possibility concerning the third-degree assault, Your Honor, but concerning the reckless homicide and the attempted reckless, those are completely harmless as to that.
Okay. Okay, explain why they're harmless with respect to the reckless convictions.
Well, again, as counsel mentioned, it's pretty hard to determine what the jury was thinking. I think the jury could determine that the defendant's actions here met the classic definition, or met the legal definition of recklessness. He took a gun to a fist fight. He didn't need to go there. He didn't need to travel across town. He had to know these other kids were like him and were capable of bad things, and his actions here and his killing and shooting of the other people met the legal definition of recklessness, and did not meet, or were not justified under self-defense principles.
Well, that latter wouldn't have even come into play with respect to the reckless convictions, right?
Right.
They wouldn't have even considered self-defense, at least theoretically.
Right. Well, they considered the evidence
They considered the evidence, but not as an affirmative defense.
right, and I think that's, to me, that seems to be the most logical way the jury resolved this case. The defendant did not need to go there. He did not need to go armed. They did not need to get involved in this stupid situation. And the question was this reckless or not? Or was the defendant blameless, and did he shoot in self-defense? And I think under the evidence, and there's certainly a clear basis for that verdict in the DVD evidence of the shooting itself.
Apart from the evidence of pulling the gun itself, the evidence tied to the defendant seems to me to be pretty much just that he showed up with his friend to a prearranged fist fight.
Right.
That doesn't sound like initial aggressor stuff to me.
Well, obviously, I didn't write this brief. I don't have my normal raft of bringing a weapon to a dispute and showing that that's an initial.
But the other side would have to know. I mean, the victim would have to know that he was bringing a gun.
I would think in this situation, well,
You're,
I would think in this type of situation, you would think, well, it appears from the sentencing hearing, people were gang members. The jury was protected from learning that during trial. I would think, if I were a gang member,
But-
that if I were in a fight, people there would be armed, and this
so
is
you're going outside the record.
I know. And the jury was protected from that. The jury was protected from that, showing that this came down to who pulled first and whether there was justification or not. Does the court have any questions on any of the other issues? I can try to address those.
Well, Mr. Kaler, recognizing that you were not the person who wrote the brief, I want to ask a question about the objection to the photograph and the AG's response. There was an objection that was raised that appears to just be a paraphrase of CRE 403.
Right.
Is it the Attorney General's position that a paraphrase of the 403 objection is insufficient to preserve an objection under 403?
I don't think I would have made that argument, Your Honor. I think for me, looking at the case in hindsight, I would not have made a preservation argument. And I would just gone straight to the merits. I've done lots of gruesome photographs case. If the photograph is of something that witnesses can describe in words, if it has to do with what happened to the victim, then it's admissible. I might also add that lately I've been watching reruns of the NCIS show, and the autopsy scenes in there are significantly worse than the autopsy photographs in this particular case. These are pretty clean photographs. Obviously, it's a real person who had a real life who was dead, and not some sort of rubber prop on a table. But these particular pictures are not bad in the universe of gruesome photographs cases. I'm thinking of the one where they had an excised liver with a dowel pointing through, showing the bullet path, and we don't have anything like that here at all. These are pretty clean photographs. Anything else? Oh, maybe if I may, let me talk about sentencing real quick. I think that is the only constitutional issue. I think Mountjoy, the recent Colorado Supreme Court case, does away with that. Juries do not need to make any sort of qualitative findings concerning either Blakely compliant or Blakely exempt findings. And what we have here, the prior convictions are Blakely exempt. I think that's a simple way to resolve that question too. Any other questions? I thank the court for its time.
Just briefly, I want to touch on the harm again about the initial aggressor instruction. What Castillo guides this court and lower courts to do is when three things are present. One, was the instruction erroneous, and did it ask the jury just generally to apply an erroneously given instruction? Two, was the defendant convicted of crimes where it applied as an affirmative defense? And three, whether the prosecution characterized the defendant as the initial aggressor in closing argument. All three of those considerations are present here. And those are, Castillo is following a long line of cases from this court in harm analysis, like I mentioned in the opening brief, with Beasley and Manzanares. And for those reasons, this error is not harmless.
Did Castillo involve reversal of both a knowing crime and a reckless crime?
I don't believe so. I think it was just an affirmative defense, but I can't remember off the top of my head. Again, though, with respect to the recklessness crimes, if the jury thought Mr. Lee was the initial aggressor, and erroneously thought Mr. Lee was the initial aggressor, and applied that finding to reject self-defense altogether across the board, which the third-degree assault conviction strongly suggests, then it could proceed to consider recklessness in the way it was instructed without any consideration to reasonableness. Now, as I mentioned, that as a matter of law, they are inconsistent, but the way that the jury was instructed, if it did find Mr. Lee to be the initial aggressor, it could reject self-defense across the board and immediately proceed to consider recklessness. So did the error possibly infect the jury's verdicts in this case? I think that standard is met here, and we respectfully request a new trial on those issues. Thank you.
Thank you, counsel, for your argument. That case will stand submitted, and a written opinion will issue in due course. This concludes our 1:30 docket. Just a moment. Counsel, you guys are excused. Are counsel ready to go for the 2:30 case? Everybody here? Yes. Yes. Is both sides here?
Not sure we have anyone from,
Yes. Looks like we have both tables occupied, so we are going to be ready to go. We are then ready to proceed in case number 18CA475. Let me, since this is the 2:30 docket, let me go through our little spiel again. This is Division 5 of the Court of Appeals. We have one case scheduled on the 2:30 docket. Counsel, you should have received instructions from the bailiff. Do you have any questions about how we proceed here? Okay. So when we begin, please state your name, attorney registration number. Remember that we're streaming these oral arguments live on the internet, and so you may wish to take care in mentioning any confidential or sensitive information. If anyone in the courtroom has an electronic device, please turn it off. We have a recording system, and that can interfere with it. With that, unless counsel have any questions, we're ready to proceed in case number 18475, Estate of Cobalon.
may it please the court. My name is Stephen Monks, attorney registration 31908. I represent the appellant, Leonard Volleson. I'd like to begin today by addressing the very questions that the court issued in its order, starting with jurisdiction in this matter. It's a little bit of an unusual case because one of the orders that we are appealing was dated November 28, 2017, but was not final until the next order came out on January 24th, 2018, which actually gives the court jurisdiction in this matter. The issue that came up was that we stipulated to the admission of will number 2, I'll call it will number 2, and the appointment of Ann Parks as personal representative. But part of that stipulation was that they were to take no position regarding a motion that we were to file to allow both wills to be probated together. They then issued less than flattering affidavits in support of one of the other parties' opposition to that motion, basically calling my client a thief and every other thing, which I perceived and my client perceived to be taking a position in that matter. The court recognized that in their order, in the first order, and actually did refer to the second motion being pending. If that motion would have been granted, it would have rendered the November order moot. And I think that's why the court even mentioned that in its first order.
So your position is the first order was kind of a provisional order?
Yes.
Okay.
And I think even opposing counsel would agree with that position as well. The second issue that I believe the court wanted an answer to is regarding this issue of a trust. There is so much ambiguity in the will number 2, and it's a handwritten, very obscure document. I think the court has probably reviewed that and would agree with me that it's very difficult to ascertain just what the decedent was trying to do there. At the trial court level, I think that everyone involved, the attorneys, parties, the judge in that case, recognized that ambiguity and in fact, many times throughout the process referred to beneficiaries and never really mentioned the establishment of a trust. I think that if in fact any trust would be established, it's going to have to be established through extrinsic evidence that's going to have to be heard extensively by the trial court to figure out just what the decedent meant. As to whether it's a public trust or a honorary pet trust or animal trust, I will say this. I think that it would have to have some public purpose to be a public trust. There's no municipal land involved. There's no educational purpose stated. There's really no purpose stated as to why it would be a public trust. As to a pet trust, just a moment, I just looked this up before getting here. I would refer to the record and tell you that there are no animals. August 15th, 2017, the court ruled Mrs. Parks will have the authority to make the decision about where the dog and cat or cats that are Mr. Copeland's property to go. In other words, they were disposed of.
But at the time that the document was executed, were there animals on the property?
Yes, there were animals on the property at the time it was executed.
So could it be construed to have been a trust for the circumstances that existed at the time of execution?
I suppose it's possible, although you could also read the will to state that he wanted the ranch to be a ranch, could be a covenant that you would place on the real property.
Well, ranch indicates animals, doesn't it?
Not necessarily. He does state in the will, I believe, that he wants animals to be there. He didn't refer to any specific animal that was to stay, I think, on the ranch. And it was a commercial operation. This is a commercial ranch. Court also authorized the personal representative to start the process of selling the cattle if the majority of the potential beneficiaries are in agreement. So the cattle were subsequently sold. So there are no animals at this time on the ranch. So I don't know how can you have an animal trust for animals that are not there? I mean, I think the purpose of an animal trust is to take care of animals that the decedent thought a lot of or something during their lifetime and that were preserved, but they're not. So I don't know what you do there.
Counsel, I want to see if I understand your position in this case. The trial court, it seems to me, said the second will, the 2017, supersedes the first. Okay, and I think your position is that was wrong.
That is correct.
And that what the court should have done is looked to the different statute and said, this second will supplements the first will, and to the extent that they are not inconsistent, they will be, to the extent they're inconsistent, the second supersedes the first, but otherwise the first remains in effect. Is that right?
That is correct. And
All right, well, if that's right, how is your client any better off under that scenario? I mean, because it seems to me the second contradicts the first as to what your client receives.
again, I think it's going to take some testimony to sort this out. When the decedent is talking about all money to be used for the ranch, is he speaking about the income from the ranch? Because it would be an income-generating entity. So I think there's a lot to be sorted out yet.
But how can that be sorted out without violating the dead man statute, for example?
It's a good question. I guess it's going to have to come down to if any other writings are found within the dwelling or bank documents or something like that that might support a different position.
It looked to me like we're stuck with the documents that we have. I could be wrong about that, counsel, but it looks like we just have these two. And
We-
trying to figure out which one controls is challenging.
But the law does say that if will number 2 doesn't make a complete disposition of the estate, then they must look to the statute and probate both wills. Exactly as you said earlier, as to the extent that they're not inconsistent. So the court did find that, the court actually found that there was no disposition in this, in will 2, but then did not go ahead and apply provision 4, which I believe requires the probate of the second document along with the first one.
Can you explain why all money goes for upkeep for it is not, all money seems to me to be the entire estate? How does that not get rid of anything that came previously?
Again, I mean, he could have meant that the income from a working ranch would be used to keep up the ranch. So I don't know, all of what money? I mean, I don't know that he was even aware, the money that came into the estate actually came from another estate. I don't know that he was even aware of what there might be. The other issue I wanted to discuss very briefly is the fact that these affidavits were issued in support of opposition to a motion that they had agreed not to take a position on.
Well, counsel, I have a question about that, because affidavits are essentially testimony, right?
That's
And
correct.
if these people had been subpoenaed, they would have to give truthful testimony, true?
That is correct, and they would have been cross-examined as well.
Right. So presumably, this is just testimony. It is not necessarily taking a position to give truthful testimony in written form or under oath, in person. So why is this taking a position?
Let me give you an analogy in the criminal context. I don't think it's a violation of a plea agreement to take no position by a prosecution if they recite a criminal history. But if they start off by saying, well, this scoundrel has an extensive criminal history going back to when he was a child and continuing till today, it is the context in which it was done. And the context of these affidavits have nothing to do with demonstrating what the decedent's intent was. They simply are slanderous, trying to belittle an honest man.
Well, why isn't any error harmless, since the court said it didn't rely on the affidavits?
The only thing I have to compare this with, because I think this is actually sort of a matter of first impression for this court, is in the criminal context, it's the act itself. They agreed not to take a position, and they took a position.
Giving testimony is taking a position?
If they would have been subpoenaed to do so, but this was voluntary in support of another's opposition to our motion.
So is this are you making an estoppel argument? It's not clear to me.
Yes, it would be basically an estoppel. They're estopped from making any argument in the case, whether it be by affidavit or otherwise.
But what would the remedy be? Because the remedy obviously can't be, well, the court can only consider the 2016 will because there are other parties involved who want the 2017 will considered, and they have to be heard, and that's what the court actually did.
I think they should have set aside the stipulation, and we would begin square one. And those persons would have had an opportunity to been heard.
But they were. I mean, you filed your motion and they filed their response. I just can't see what would have been different.
As far as, and I guess I'm not clear on what you're asking as far as what would have been different.
Well, you're saying that there was this breach of the stipulation.
Yes.
And I'm trying to get to, okay, let's say there was a breach of the stipulation. What would have transpired differently? I mean, you had already filed your motion, okay?
Mhm.
There are other parties, not the parties who filed the affidavits, who responded to that. They were entitled to do that, asking that the 2017 will be probated as well. Okay, they're entitled to do that. I mean, your stipulation couldn't bar them from doing that.
That's correct.
And so the court would have been in the same situation. Consider your motion and their response and decide what to do with these two wills.
Again, I hate to go back to this, but I think it's the act itself. If they would have set aside the stipulation, we would have been back with two competing wills, which we would have had hearings on. Those parties, the Allen Bowler parties, would have had an opportunity to be heard again.
Well, and presumably, the parties who gave the affidavits, if called as witnesses, would have testified consistently with the affidavits, and they would be permitted to do so, wouldn't they?
They would be, and I would have been permitted to cross-examine them, call witnesses who would disprove what they're saying and everything else.
But given that the court disregarded their testimony, you have no harm from not being able to cross-examine them.
I'm not sure that we don't. Reading the order, I guess, is very confusing at best. I'm not so sure that the court wasn't influenced by that. I mean, I think it's possible that sometimes we're all humans. We read this material, we try to set it aside, as you said, but did she really set it aside or not?
Well, counsel, did you request a hearing on your motion?
I did not request a hearing on our motion. We had, among the attorneys, had talked about that and did not think it was necessary. Matter of fact, opposing counsel at the time, I think, felt very strongly that the motion would be granted. Any further questions?
Thank you for responding to our questions that we've posed.
Thank
We
you.
appreciate it. And I extend my thanks to you, counsel, as well. Presumably you will answer the questions we've posed as well.
Oh, certainly, Your Honor. And I'm Stephen A. Brunette. I'm counsel for Ann Parks, who's present here today. And also her attorney below is present here today, Julie Papa. 26387 is my registration number. I'd like to start, if I may, with the fourth question on your list, and that is, it appears from the record we have in front of us that the probate magistrate, described in the will what looks like a trust was created. She didn't make any rulings regarding the existence of the trust yet. So I think that as to the fourth question, we would request that the court either resolve what kind of trust this is, or preferably, in the court's discretion, remand with instructions or directions for the probate magistrate to make a record of, what type of trust this is. I think clearly the language says it's a trust, and Ann Parks is mentioned several times to be the one to be responsible for it. He designates a particular trustee, but I think that at this point the record could be strengthened in that regard because the court didn't directly address all of the factual elements of a trust.
Counsel, that leads me to my concern, which is I'm not exactly sure where we are in this case. It seems to me that the court has ruled that the 2017 will supersedes the 2016 will,
Yes.
but that there are a number of unanswered questions and ambiguities in that will. Who are the beneficiaries? What kind of a trust? Is it even a trust? Who are the trustees? What do we do? What is the nature of the $5,000 that is to go to your opponent? I mean, there's just all kinds of unanswered questions. And given those unanswered questions, do we have a final judgment in this case?
I say we do, Your Honor. We have a will was admitted to probate. It was stipulated to be admitted to probate. And it does address, there's no particular beneficiary, but there, as I understand it, 3 types of beneficiaries, or non-beneficiary trusts in the common law. And if I look at the ruling in the case that you cited in your questions, that foundational point that the court has jurisdiction over all trusts, including trusts where there's no designated beneficiary, the court forever has had jurisdiction to determine the type of trust, and just the whole entity itself. It appeared to be 3 different types of trusts that are consistent with the Uniform Trust Code that was just adopted as well, that may be possible here. The one that appears from the evidence we have at this point is it's a non-testamentary, it's testamentary trust, but it doesn't designate a beneficiary. So there's no beneficiary designation. So the statute that I filed from the Uniform Trust Code would seem to, at this point, apply to this case. That would be 15.409.5, which specifically says that to the extent, even the title of it, if you have a non-charitable trust without an ascertainable beneficiary, or a trust for the care of an animal, which I think this is as well, I'll get to that in a minute, that it can be administered by the trustee and can be used for, what's specified in the trust. But if the trust instrument doesn't designate, what it would be used for, and if no taker, as it says in 15.409.5, 1B3, says if no taker is produced by the application of 1B1 or 1B2 to the settler's heirs, then it would go to the settler's heirs if there's no taker under the other provisions. Now, a charitable trust typically would be for a charitable purpose. Charitable purposes are defined in 15.5405 as such things as advancement of education or religion, promotion of health, government, or municipal purposes, or purposes to achieve something that's beneficial to the community. Now, we don't have on the record we have thus far evidence regarding that. So I would think that that might be something that the probate magistrate could take evidence on, see if there's any, intent related to that.
Well, counsel, that's my concern. I mean, that we don't know, there hasn't been evidence, there's been no determination on these matters. So how have the parties' rights been finally determined? And that's the standard for a final judgment that's appealable to this court.
Sir, I think the final determination, Your Honor, is that this will has been admitted, to probate. And the only issues on appeal from what was resolved below relate to whether it revoked the previous, holographic will under the language of the statute and under the law we cited in our brief. The question of whether this is a trust or what needs to be done with it actually is not at issue in this appeal. We refer to it in our brief in the context of saying that there's no error or abuse of discretion in the probate magistrate deferring a determination of that until later. It wasn't required under the statute, so she could defer it until later. The 2 heirs that appeared below argued through their counsel, Mr. Enoch, that this was a trust. It was created as a trust, but the validity of it has yet to be determined under the terms of the second will. That was the argument. The court didn't address the argument, but did defer. I'm sorry, Your Honor.
No, that's okay. So is it your position that any time a court determines that a will be accepted to probate, that by itself is necessarily a final judgment subject to appeal?
To admit a will to probate, I think that is a final, order.
Is there
Under the
is there a
statute.
statute or a rule or a case that says that?
I think it's just a statutory matter, Your Honor. If the court is, a will is admitted, is offered for probate, it's admitted to probate, and the court made a determination as to the, whether it revoked the prior instrument under the statute and determined that it did, and therefore it impliedly revoked the previous instrument, and therefore it was admitted to probate, and the prior one, was not. So I think that is a final determination. Now, under Rule 54, of course, the court can change its mind if new evidence comes in, but based on the record we have at this point, the court, I think, made a very clear, meticulous, careful inspection of two very difficult, handwritten documents based on the documents plus summaries of the documents provided by the parties who were litigating below, and came up with a summary of what is in, both wills that neither party questioned below. So I think that's a final determination, that this, will has been admitted to probate. The second one, and it revoked by implication the first. Now, the question as to the
Pardon me,
trust, which
counsel,
court,
before you move on to the next point, you said admitting a will to probate is a final order. Is that by statute, or is there a case that says that?
Your Honor, it just seems to be fundamental to me. It's admitted to probate. The court may change her rulings at any time. You petition for formal probate of a will under the particular statutes. I can't pull the particular statute up for you right now, but
Thank you, counsel.
just. Now, concerning the trust for care of an animal, I think there is a trust for care of an animal. There are cats on the property. They come and go. There are horses still on the property. There are two particular cats that were mentioned, so I think that there is a trust for the care of an animal, or a few animals. I think let me get to the questions again. Well, as far as, I guess I have addressed 4 and 3. I think the decedent did intend to create a trust, as to question number 2, did intend to create a trust, because the language is there. The cases I cited in the brief say if the intent is there, the intent can be stated as, I'd like to create a trust. Now, it's a trust with no beneficiaries, but the code contemplates such things, because the 409.5 clearly, specifically, even in the title, contemplates that there will be trusts that do not have a designated beneficiary, and specifies the procedures for dealing with that. As far as the question regarding whether the probate, whether the ruling was final on November 28, what I run into there is it says real clearly that there's another petition has been filed. I agree basically with the appellant on that point. And I can't imagine that, given that order and the language that says that, one will has been admitted so far, but, there's a petition to set aside this, first one. I can't see requesting the court to issue a final order on that, or to issue a Rule 54 order that says this is a final judgment. I know I wouldn't ask for one, and I can understand why opposing counsel wouldn't ask for one either. I think it was there. Now, as far as the, there's no question that a Rule 60 motion does not stay the time for filing an appeal. Rule 59 motions do, Rule 60 does not. But that didn't seem to be relevant here because the order wasn't final until, the court says, okay, I'm going to uphold admission of the, second will to probate. And I'm wondering, gosh, I feel like I should have a statute on when a will is admitted to probate. Now, when a will is admitted to probate, I think that's a final appealable order, is it not? I actually would have to look at that. I must say, you've stumped me on a basic question that I should know the answer to. But the will is admitted to probate, and then this will was not admitted to probate. That was a final appealable order once the decision was made.
Either way, admitting or declining to admit would be a final appealable order?
I'm sorry, I'm trying.
Either admitting a will or declining to admit a will to probate would be a final appealable order?
Well, I think declining to admit a will would be a final appealable order. Now, admitting a will to probate, because the court can review decisions anytime along the way, you know, and I think if it were remanded, this will has been admitted to probate, you know, is the current status of it, as I understand it. And, or that's how it looks on the record. This will is admitted and it revokes the prior one. And frankly, I've never had to research the question, Your Honor. I guess feel like I should have looked at that. I apologize. Okay.
Would you like to call a friend?
Call a what?
Call a friend.
Well,
from a
you know,
TV
you
show.
stumped
It's
me,
from a
and I
TV
feel
yeah.
like, well, I feel pretty horrible about that. I think, other than that, I think the arguments are fully briefed in the briefs that we filed. I think the key point in Hagan, though, concerning the trust, which is the testamentary trust is specified there, but I think a remand to the probate magistrate to make a determination as to what this trust is and how it should be dealt with under the court's broad inherent jurisdiction over trusts. Unless this court wants to define what the trust is based on the record that's here. But my impression is that it might be better, this court might better appreciate a more complete record as to the trust. And also, I'm sure that Division W and counsel for the estate would appreciate directions or instructions. This is an interesting situation, given the holistic will, and there being two of them. So we basically, everything in our brief covers that. Are there any other questions I may address here, or?
There's no question you've brought us an interesting case.
No.
Thank you,
Well,
counsel.
thank you, Your Honor.
I have some time for rebuttal.
58 seconds, it looks like.
I'll hurry. I just wanted to point out to the court that the first thought of a trust or anything came about here in this court. There's no mention in the record, I believe, at all about the creation of a trust. I think that issue is raised the first time here in this court. I think that in itself demonstrates the trial court's reluctance to establish a trust. Any questions?
Counsel, what is the record on that? Has the trial court declined to recognize a trust?
They have done nothing other than the order admitting it to probate that was stipulated to, and the order denying our motion to admit will number 2. So there's been no reference in the record at all regarding a trust or disposition in any manner.
Thank you, counsel.
Nothing further.
Thank you, counsel, for your arguments. The case will stand submitted and a written opinion will issue in due course. This concludes the oral arguments for Division 5 today. The court will be in recess and available so announced.